Hello, my name is Ellen LaPlante, and I'm an attorney at Unsworth LaPlante. I'm going to be talking with you today about the basics of estate planning. When I think about estate planning, I like to think about it as a pie. Anybody who has an estate plan has a pie made up of different pieces, but those pieces are going to look different for each individual person and their needs. A common tool in estate planning is something called a power of attorney. Others include things like advanced directives, trusts, and wills. And we're going to take these in turn and look at what each of these tools can do for us in estate planning. When we think about estate planning, we're thinking about what important goals or concerns somebody has and what tools can be used to address those. So, a proper estate plan can include things like financial powers of attorney that give somebody the ability to make financial or legal decisions for you if you're unable to do so for yourself. They can include a healthcare directives that give somebody the ability to make medical decisions for you if you're incapacitated and can't do so. They can give you the tool to designate guardians if you have minor children. And they can allow you to put in place tools that can protect beneficiaries, prevent family disputes, and make sure that your wishes are adhered to. They can also include tools that avoid probate and plan for long-term care expenses. A power of attorney is going to be the document that gives an agent the ability to make all financial and legal decisions if you are incapacitated. Oftentimes, a power of attorney is going to handle things like paying your bills, managing bank accounts, dealing with real estate transactions, and filing income taxes. A power of attorney can also give somebody the ability to deal with long-term care or Medicaid if that is needed in the future. A healthcare agent is typically named in a document called an advance directive. And the advance directive is going to give somebody the ability to make medical decisions on your behalf if you're unable to do so because of incapacity. An advance directive can give somebody the ability to exercise your wishes regarding end-of-life care and sign do not resuscitate orders. In addition to an advance directive, it's important to have a HIPAA release. This gives your agents the ability to see all medical records and know what is happening from a medical perspective. Without advance directives for healthcare, your family may end up in the probate court for a guardianship to be deemed as your healthcare agent. A will is one of the most common tools in estate planning, and a will is a legal document that outlines how you wish your assets to be distributed at your death. Within a will, you can specify how you want your assets to go, who you want them to go to, and how you want them to be distributed to those beneficiaries. In that will, you name an executor, and that executor is the person who's in charge of settling your estate. One of the critical things to understand about a will, in addition to distributing assets, is the tool that you name guardians for minor children. But there is a huge misconception when it comes to wills. Wills do not avoid probate. Wills are a ticket to probate court. Their goal is to give a judge directions of what you would like to have happen to your assets upon your passing. And if probate avoidance is a goal in your estate planning, a will may not be the best tool to accomplish that. So oftentimes we hear the question, what is the difference between a trust and a will? In general, as I said, a will is directions for a probate court. A trust typically distributes property outside of the probate process. A trust is a legal entity that holds and manages your assets. I like to think about a trust like a box. You title your house, your bank accounts, your investments into the trust, and the trust takes control of those assets in the box and provides the rules for how they should be distributed to beneficiaries. A trust always has a trustee, and that trustee is the person who manages the trust and makes distributions in accordance with the trust directions. Generally speaking, there are two common types of trusts: revocable trusts and irrevocable trusts. A revocable trust, which is more common, is a trust that can be amended or revoked during your lifetime. The grantor, or the person who sets up the trust, retains full control over the trust and its assets. If you are the grantor, while you're alive, it's business as usual. The trust is simply a standby device. So you can still buy assets, sell assets, refinance assets. There's no new income taxes, no new property taxes. The trust acts as a joint bank account, but much more powerful because it's not just you or a joint owner who's in charge. You can name successors down the road to take over and manage the trust. And you can add assets to the trust or take assets out at any time during your lifetime. An irrevocable trust, on the other hand, cannot be amended or revoked. An irrevocable trust is typically set up for a very specific reason. For instance, you could have an irrevocable trust that is an advanced estate planning tool used for long-term care planning, so that assets that are put into that trust cannot be attached by the government if you need long-term care at some point in the future. Irrevocable trusts can also be used for things like asset protection, estate tax protection, or any other tax benefits that you might need. If you are interested in doing estate planning of your own and wish to meet with an attorney at Unsworth LaPlante, please reach out to us at www.unsworthlaplant.com.